So hello and welcome to a private roundtable conversation focused on how we can address challenging data issues that span across sectors, nations, and societies. This is a continuation of a Data Salon series, and we're proud to be working with Accenture on this event. This is a recognition that we have to address these pressing data issues if we're to work collaboratively across borders and across societies. With that, I'd like to introduce the co-host and the original organizer of this event, Stephen. Stephen, could you introduce who you are and help also introduce our speakers for today?
Thanks, Dr. Bray. Hi, this is Stephen Tiell. It's so good to see so many of you, so many familiar names and faces eventually. I'm Stephen Tiell at Accenture. I lead responsible innovation. And we started hosting these events and similar events a couple years ago, and we're just so pleased to be in partnership with the Atlantic Council in how we move this forward. With that, it sounds like the construction has just started, and so I'll make quick introductions. Today, we'll be hearing from Dr. Jen King, who is the Director of Privacy at Stanford Center for Internet and Society. Her research really focuses on the public's understanding of expectations of privacy online and the policy implications of that emerging technology on consumer privacy. And then we also have Jana, who is a member of a legal policy advisor for the European Parliament, member Alexandra Geese. And she's also a former negotiator for GDPR. So we're really pleased to have both of them as we talk about this what I think is the sexy topic of notice and consent.
Thank you. You know you're in the right place when people think notice and consent is a sexy topic. Thanks, Steve. And so I'm going to talk today about some work that I've been kind of chipping away at for the past year around notice and consent. So let me first just say that I am an information scientist by training, though I work in the law and policy space. And so I am just dangerous enough to know a lot about the law, but not be a lawyer. So don't take anything I say as legal advice, please. And my collaborator that joined me today is Jana Gooth. Again, she is a lawyer from Germany and again works for the European Parliament. And she joined me last year at Stanford to help get this project kicked off. And so I come to this really out of frustration. Again, as an information scientist, I study human-computer interaction. And then my main area of scholarship is privacy, data privacy, information privacy. And again, as Steve said, really trying to understand how people think about privacy. And you know, like everybody, I also find myself having to click through notices, privacy policies, and consent screens that don't help us, that are completely illegible, inscrutable, not user-friendly in any way. And for the most part, I see them as a barrier for us in terms of thinking about how we get consumers kind of either better informed about privacy and as a way to claw back some of the rights that I think they're forced to give up in those processes. And so having conducted research in the privacy policy space, I started trying to think about what could we do in this space to really try to make a difference. And I think it's a really timely topic for a few reasons. One, and Jana will talk more about the GDPR in particular, as she worked in the negotiation process on the GDPR. You know, we do have the GDPR in Europe, which kind of minimizes consent as one of the key ways that you can obtain people's data, but it's still obviously an important part of the process. But looking at the US in particular right now, and I don't know how many of you are in the US right now, but we lack a federal privacy law in the US. And there's always, you know, speculation we're going to get there. I think the timeliness is probably better than we've seen in the last 10 years, if nothing else, because we have the new California privacy law, the CCPA, put into effect. And that will inevitably put pressure kind of at the federal level to respond. We also, for those of you who don't know, are most likely going to see a CCPA Part 2 coming in November. It should be on the California ballot, and so we'll probably see another round of privacy legislation here in California that will undoubtedly turn up the heat even further. And so as we kind of look around this space and we think about what can be made better, notice and consent to me is one of the obvious things. Unfortunately, I think it's also one of the hardest things we can potentially try to improve. And so my perspective is not so much looking at the legal frameworks around notice and consent, but really trying to think about it from a design perspective. Again, as someone who has studied human-computer interaction, I look at notice and consent really as a kind of design problem. And that is in part because it happens on the screen. And so much of it is really predicated on people trying to consume and understand information. And what we see is that we've taken a system that essentially kind of is derived from legal contracts and was basically just transferred from the world of law and contracts to the screen in a way that has never actually been thoughtfully designed. It's never been really thought of in a way, how can we actually improve this to make sure people really understand the notices they see? How can we more effectively communicate the information that people need to consume in order to make decisions about what data they want to share? We've seen none of that. And if you look at the history of the process, it's never been quote unquote designed. And so, basically today we are stuck with a system that at the most basic level doesn't scale. And so I think everybody knows this probably almost intuitively, that if you think about how we manage your information, I mean, so much of the whole entire system that we interact with is predicated on this premise that we can actually take the time to read notices, understand what they say, and make concrete decisions about the companies that are requesting our data across multiple contexts. And I obviously focus a lot on the consumer context, but this can span beyond just the Googles and the Facebooks. I mean, we can go into the medical world, we can go into health tracking, you name it. I mean, so it's not just kind of the common platform issues that we think about, it goes everywhere. And so what we see is that it doesn't scale. And there's been numerous research, numerous studies that look again at how privacy policies are designed, whether people can understand them. What we know is that they're written for lawyers, by lawyers, for lawyers primarily. They're not consumer communication vehicles. And interestingly, I think what we also find is that if we tinker around the edges of what we have today and just try to kind of improve what's there, which we can do, and there's a lot of good research that points to immense improvements we could make just to the existing structures. Even so, we have kind of an incentives problem, which is that for the most part, companies really benefit from the existing status quo. And I have some anecdotal kind of evidence that points to, if you actually do try to improve the existing system, often you find consumers recoil, because when they're actually faced with more concise communication about what's happening to their data, even if those practices aren't unique, even if it's just company A decides, hey, I'm going to actually try to do a little bit better in this area and try to show consumers what's happening, we find that consumers actually often panic when they see more explicitly when they're told very clearly what's happening to their data. And so we also have a major incentive problem, because for the most part, you're not going to see many companies kind of put themselves out there to potentially harm their turnover. If what you find when you actually take the time to improve notices, that in fact you end up losing customers because people are really concerned about what's happening with their data. And so in my view, one of the best things we can do is really try to think about how to improve user trust. And so I think that's one motivation for trying to improve notices. But clearly we need a solution that goes beyond just tinkering around the edges and thinking more carefully about what we can do. Okay, so what I've done so far and what I've done with Jana is we kicked off a project last year with the World Economic Forum. And we held a conference back in October where we brought a pretty diverse group of people to the table to really try to think through, what are some of the issues we can deal with here? And what are some of the solutions or possible ways we can kind of chew around the edges of this problem to think about how to reframe notice and consent. And so, so this group came up with about 9 or 10 different solutions. None of them, I would say, are kind of precise solutions, meaning that this is not a blueprint from here to there, but they're different ways about thinking about how we can actually tackle the problem. And so I think on one level, we could think about is whether we would just simply reform kind of our legal approach and take certain data practices off the table. And so, I think in some ways that would be ideal, but we won't necessarily get to that point. So with the group we worked through a set of design solutions and a set of regulatory solutions. I'm going to go through each of them just very briefly, and then talk a little bit too about kind of what are some of the challenges that we face in passing legislation. And then Jana will talk a little bit more about kind of what are some of the concerns we have with the EU. And so, so this group came up with 4 solutions that were really focused on a design perspective. And again, as I mentioned, there's ample research around kind of notices today where we could absolutely make improvements to the existing framework. But the problem again is that the existing framework does not scale. Okay, so most of us just don't have the capacity to actually make the decisions that we need to make on a case-by-case basis to really understand who we're actually engaged with, who we've said yes to, and of course you have the problem of I may have consented to the use of my data from a company today. How on earth will I actually manage that relationship or remember that over time? And so one of the solutions that was suggested really is not new. And I think though we're at the point where we could actually begin to consider that we have the infrastructure and potentially through the deployment of mobile phones, a means to actually start thinking about this as a realistic solution. And that's developing personal user agents. So a software-based solution that helps you manage your consent relationships, not unlike how we do today with password managers. And again, I think this idea has the basis in P3P, and I don't know how many of you are familiar with P3P, which was the original kind of privacy browser language developed back in the late 1990s, early 2000s. But this is not a new idea, but yet we think that it's one of the more kind of compelling ways that we might be able to actually try to make help people manage this solution, as long as we're focusing on individualistic solutions. And so I think that's one of the things you'll see as I go through these. There are a number that really focus again on the individual, but there's also a sense that this is a bigger problem than just individuals, and that we may need to look at it with a broader approach and find more collective solutions as well. So personal user agents, again, was looked at as a key way we could probably develop capacity for individuals to potentially manage these relationships. Another idea was actually trying to build out knowledge around policymakers. And so we know today that the lack of kind of expertise in the policy sphere, just around technology in general, but in particular, these kind of thorny issues around human-computer interaction is low. And regrettably, I don't think we're yet at the point where we're going to see governments hiring the kind of people we think we need to hire, at least potentially not now as we look at a global pandemic and tightening of budgets and such. And so another tool that was proffered was the idea of building data visualization tools specifically for policymakers as a way to try to help educate people, or policymakers in particular, about data flows and how data moves through a system, and trying to both kind of conceptualize how data is presented from an individual point of view, but also from a systemic point of view, as a way of trying to educate policymakers to help them understand when they're making decisions around data, to really kind of understand that bigger picture. 2 other approaches really focused on thinking about public spaces. And so that was a theme that came up repeatedly in discussions around notice and consent. Was, again, so much of this we think about in the individual context with us in front of a screen, making a decision around a particular company. And what the group we convened really seemed to keep hitting on was the idea that we're moving into a world where consent becomes a much more difficult thing to navigate and to obtain when we are thinking about using ubiquitous technologies. And so, some of the things that came up in discussion were the use of facial recognition technology, which of course is a very controversial subject, but just again, basic IoT deployments, the use of IoT, not just in the private sphere, but in the public sphere, smart cities and such. And so we had 2 solutions that were really trying to focus on, again, how do we build opt-out strategies for people in public spaces when they don't want to be surveilled or when they don't want to be monitored in some way. And related to that, again, was what some of the participants call the design justice approach. So trying to build out a justice approach to smart cities in particular, but I would say that was a theme throughout all the work we looked at, again, was thinking about it in terms of a broader kind of group of people than we traditionally design technology for. And so these are the most marginalized, the most vulnerable. And again, trying to bring that perspective to how we think about consent, because one of the themes that also came up in the discussions we had was a real focus around the fact that, for the most part, design discussions really traditionally have not included people who kind of live at the margins. Mostly we focus, and if you work in a technology company, you know this, when you're building technology, for the most part, you're thinking about customers and you're thinking about people who most likely can afford it. But you're not often thinking about the questions of ethics and designing technology for more vulnerable communities. And as we deploy more technology in public spaces, this becomes a really primary concern. And so those were the more design-focused themes that came up in our discussions. We also had a set of regulatory proposals that came up. And again, these are all just kind of bits of a puzzle. No single one of these is like the aha, this is going to solve all of our problems, but they all point to some different themes that I'll tease out towards the end here. So in terms of regulatory focused proposals, we heard a lot about data trusts, and I noticed in the comments that people submitted today that there was some interest in data trusts. And so that was definitely a major point of discussion. I won't go into depth on data trusts, just suffice to say, the basic idea is, can we get away from these kind of individualistic ways of sharing data and try to think about more community or broader population focused solutions for sharing data? And so I don't know how well data trusts will work in the kind of individual data market in the sense of me dealing with different companies, but one of the ways I've heard them discussed multiple times has been potentially in the health market and thinking about genetic data, for example. And could you pool your genetic data with other members of your family to create a data trust? And then could the trust then be the means by which you engage with, whether it's a 23andMe or medical research, but just a different kind of regulatory vehicle for thinking about how we consent to use data and how we hold data potentially in common, or at least in a way that has more kind of guardrails on it than the traditional, I sign my rights over to a potential company and then who knows where my data goes. Additionally, we had some discussion around positive regulation, which really comes down to questions of incentives and not so much prohibitions on use of data, but how can we build kind of positive ways of encouraging companies to take responsibility for data. I don't have a lot of details on that one, but suffice to say, it was really just a focus on, instead of just saying no, what are ways you can encourage data sharing without necessarily being prohibitive. Algorithmic explainability was another theme in our discussions, which obviously goes a bit beyond kind of just the data sense into, goes into AI. But this was really seen as a core issue. And I know if any of you are dealing or thinking about AI, you've probably heard discussions of algorithmic explainability, but it really goes again to the sense of people needing to understand kind of what's happening to their data, who's in control, what are the decisions that are being made about me, and making that kind of a key aspect of whatever way we deal with collecting data from people. And then the last two, there was discussions around creating a legal basis for limiting generalized surveillance. Obviously, this could have a lot of trouble deployed on a global scale. There are going to be countries that will be extremely embracive of something like this, and there are going to be others that do not embrace this idea. But in general, there's a lot of concern, again, going back to that idea of, could you create opt-out strategies for collecting data in public spaces? And again, that is something that you might be able to use a smartphone for. It might be a software-based solution. But there was a lot of concern that we actually needed a legal basis, and this is probably a little bit more US specific, although I think it's also applicable in the EU, around not just declaring public spaces as a place where it's a free-for-all for collecting kind of any kind of data you want. And I would say that probably extends to some extent not only to physical public spaces, but also potentially to virtual public spaces. And I understand that many of you are data scientists, and I think you may run into this concern with your own work, or if you haven't, I've certainly heard lots of concerns about this from my perspective, of the idea of the taking of public data, quote unquote public data, especially consumer data, from people who think it's public, who don't actually understand that aspect. And so there was a question of, could you actually put limits around the collection and use of quote unquote public data, but specifically surveillance data. And then Finally, there was discussion around creating a harm assessment process for data collection, which I think was a somewhat controversial topic, but again, trying to think through whether there are contexts in which you could actually say, this particular practice has a certain harm level associated with it. And from a company's point of view, having a way or a metric potentially to say, hey, I want to engage in this set of practices, and there's been an independent body that's essentially kind of assigned a risk level to them in a way that is standardized, so that there's less kind of ambiguity around saying, I'm going to collect this type of data, or this data about this topic or this context, and that there's more clarity around kind of assessing the potential harm from that approach. But I think one of the key pieces of that was, again, thinking about harm, not just from a company's point of view, which I think is often how we think about it in this space in terms of liability, for example, but trying to also articulate harm for individuals. How do we think about harm in terms of data collection from a consumer point of view or the public point of view, and incorporate that into some framework for thinking about how we assess harm. And so that's kind of an overview of where we ended with our process back in October. There's a lot of different ideas there. We'll see kind of which direction some of these go. But again, none of them really focus explicitly on just tinkering around the edges of design, but we're much broader in terms of trying to rethink what are some of the ethical underpinnings here? Like, what are some of the things we need to kind of push back against and really find an ethical grounding for these different practices, and find a way to communicate to people and actually give them back more control than they certainly have today. And so I want to shift for a minute to talk about kind of what are the challenges ahead in terms of thinking about how we do any of these things. And so I'll start by saying in the US, I think, we have a few challenges in terms of reforming notice and consent. One, again, is thinking towards federal legislation, and to some extent really trying to advocate to policymakers that this is a priority. Getting that on kind of the list of privacy issues that we see. I mean, in the bills that I think that have come up to date, I'm not sure any have tackled notice and consent. The new California law that's in effect now adds a little bit of clarity around privacy policies, but really doesn't touch this concern at all. The normative assumptions around, you as an individual can make these decisions and engage in that kind of privacy self-management are still there. I think one of the big challenges around this, though, are rethinking just data protection in general. And so I know Jana can talk a little bit more about this, but I think one of the biggest challenges we have here in the US is that privacy is not a human right the same way it's articulated in the EU. Very much our expectation of privacy is derived from the US Constitution, the Fourth Amendment, and in practice, though, it's really a consumer harm issue. And so much of the challenge we have in thinking through privacy kind of on the legal side of things becomes because so much of it is dependent on kind of proving consumer harm, and whether that's a financial harm. Well, generally it's looked at in terms of a financial harm. Trying to get the courts to think about privacy in a bigger way, to think about it as a dignitary right, for example, or dignitary harm, is a real challenge within our current legal framework. But I would say anything we do at the federal level really needs to kind of rethink privacy, not just as a consumer harm. My hope is that, I think our best hope is to think about it more as a fiduciary right. And so there's been some interesting scholarship focusing on how to reframe our privacy obligations in terms of fiduciary duties. And so that, I think, is probably one of the easiest ways into kind of reshaping the kind of legal framework to potentially think more broadly about some of the consent issues that I've raised. Because as long as we kind of maintain this focus on the fair information practice principles, which are really kind of the undergirding for this entire approach, this idea of, again, that you can, rationally as a human being make these individual choices about privacy, and it's all based on, the information presented to you. As long as we kind of stick to those core principles and don't kind of acknowledge some of the ethical issues that are entangled in all this, then we get really stuck. So I'm going to pause and hand it over to Jana to talk about the EU perspective.
Yes, I'll keep it brief so we have enough time for the Q&A. Maybe just two remarks to the legal framework, how it is in the European Union and how it also affects lots of companies from the US. Is what most people don't know or aren't really aware of is that GDPR isn't the only privacy law that's super relevant inside the EU. There's the GDPR, obviously, but then there's also the e-privacy regulation or the e-privacy directive, which is being reformed right now into the so-called e-privacy regulation. And the latter one concerns anything that's electronic communication services. So everything we see online, basically, all the cookie notices, that all falls under e-privacy actually, and not under GDPR. So we have these two different legal frameworks there, and what's notable about both of them is that so far they don't have any provisions on the design aspect of notice and consent either. Just like Jen mentioned, there's no incentive whatsoever for companies to progressively think about how they can enable consumers properly and not only have them tick boxes, which everyone's just annoyed by, and it doesn't serve anyone properly. So yeah, the situation actually isn't that different from how we find it in the US, even though the legal concept behind it is so different, where in the EU we have privacy as a fundamental right. In practice, it doesn't really change a lot, right? We have the notice and consent framework, just like you know it from the US as well. And one thing that's interesting, though, about the reform of the privacy directive right now is that there are some ideas out there actually in the Parliament's position, which has already been adopted, to outsource the decision on what I want to consent to when I browse the web to the browser level, actually. And the Parliament proposed that a browser needs to implement the most privacy-friendly settings by default, and then the user would have to be asked or informed if they want to switch those settings and if they want to allow cookies for marketing purposes or for similar purposes. So there we would have one of the examples that Jen mentioned, where we could kind of outsource the decision of what I want to consent to online. But that's been stuck in the legislative process for 2 years now. So we'll see if we'll get it moving forward. It was supposed to move forward this fall actually, but now with the coronavirus, there's lots of other topics on the agenda right now. So we'll see how that'll go. But that might be one of the instruments where we could have at least some kind of progress in how we can build on notice and consent.
So
I think we'd be happy to take questions at this point.
maybe we can now turn to questions. So thank you both, Jen and Jana, for that very in-depth overview. Really appreciate the overview. We're going to turn to questions now. So this is the part where we're looking for questions that are part of the conversation. Later, we will shift to non-attribution. So it depends on whether or not you want to have your question be part of the recording or not. If folks want to turn on their video, that's a good way to indicate that you have a question. And while we're doing that, actually, Jen and Jana, I had a question, which was, you were talking about how people talked about doing this at the browser level and recognizing browsers are just one part of the world that collects our data. I guess the question I would also ask is it possible that maybe you could have different groups sort of putting forward, both for browser, but also for phones and other digital appliances, these are what we have chosen as our recommended, maybe we're middle of the road, maybe we're going very far one way or the other way, but then people could almost sort of subscribe to whatever that group represents. And so that way it takes some of the cognitive burden off of everybody having to decide it, and instead you can rely on groups. So I'd be interested in your thoughts there.
Yeah, I'll take that. Definitely. I mean, like I said, this is not a new idea. I've heard many variations of it floated over the last 10 or 15 years. I think when it was first kind of floated, we didn't have the technology, right? Or we had the browser, but even the browser was seen as a very limited kind of way of managing this. Right. And so, yeah, I think there's always been a kind of an assumption with this approach that you would have a, if you wanted to follow the advice of the ACLU or the EFF, for example, they would assumably create some kind of suite of basic privacy preferences that you can install, for example. I do think there's been a little bit more focus on taking this idea outside of the academic realm. Again, I've seen it kind of tossed around in academic circles for a long time. But I actually think there are, I've heard, I don't know if there's any particular companies kind of focusing on this specifically right now, but I've certainly heard interest and potential kind of company ideas floated my way over the last year or two in this space. And so I do think people are thinking about it in terms of a consumer-focused solution.
Excellent. Another question then that I would have for both of you, and then we'll go to James Williams for the question after that. question I would ask is you talked about, fiduciary responsibility and possibly reframing that here in the United States. And we do have, companies are required, if some companies have to do a 10K filing that sort of discloses their financial flows. Maybe do we need to start thinking about that, much like how you have to disclose your financial flows, maybe certain organizations also need to disclose their data flows and their data uses, which then also creates maybe a responsibility to have a data ombuds function that actually considers not only is the data following the appropriate notice and consent and is involving the ability to opt out or opt in, but also sort of, is it characteristic of the right problem? Is it not being necessarily skewed and non-representative of certain groups? And so could there be a data ombudsman function, but then also disclosure on an annual basis, as whether it's part of an SEC filing or something like that, that could allow people to then take a look at it and say, why are they connecting these two different data sources? Does it make sense? And so maybe that puts more of a public reporting responsibility on organizations.
I think that's a really interesting idea. I've heard versions of that floated, especially around AI and again, in algorithmic explainability. My key concern right now is that I'm curious, like who will do that work? So it's one thing to, as from a company point of view, to have to chart that out and to present that. Who will audit it? And I think, we'll see in the US at least, and I'll let Jana respond too, that there'll potentially be an industry of maybe the kind of traditional accounting firms we see today, but others who step in to fill that void. But my biggest concern right now is, at least in the US, we do not have the government expertise, I think, to conduct the type of kind of audits that I think that implies. And again, when you're thinking about something like algorithmic explainability, just to kind of sit on that topic for a second, that's been raised in the context of AI around, especially around, and I think the GDPR, in fact, may call this out explicitly, where the biggest concern right now around systems that actually have a direct impact on decision-making on behalf of humans, whether that's, algorithms that potentially make decisions around public benefits or around, prison sentences or what have you. Of course, already in the US, we've seen some fighting around kind of trade secrets and making those things explainable. But even so, if we have a regulator, let's imagine our future privacy regulation in the US either gives the FTC more power, more capacity, or we see the creation of a new privacy regulator, because that's been proposed on the table as well. That's an interesting set of expertise I think you're going to need in order to kind of evaluate those things and conduct it. And I, as much as I would like to see our government step up and see much more kind of technical expertise in government, we're certainly not there. And so to me, that's like the big missing piece right now, is who is actually going to conduct that work. And again, I would imagine here the private sector fills in. But Jana, do you have any other things you want to add from the kind of GDPR EU point of view?
Yeah, under GDPR, there is in fact an obligation to do so, but not publicly disclose this information, but just towards the supervisory authorities. So they already have these audit rights, and the companies need to be ready to be able to present them this data. So they have to already, compile it in a fashion that the supervisory authorities then can check what they have been doing with the personal data they collect. But just as Jen said, there's a huge lack of expertise there, or just of staffing, basically. I mean, I'm not saying that they're not experts enough to do it, but it's just they're lacking the manpower to do so. We've hardly seen any proper enforcement of GDPR, if we're honest to ourselves. The Irish Data Protection Authority, who's in charge of most big tech companies, they haven't fined a single company yet. They haven't fined a single dollar. So we're 2 years in of GDPR, right? So there's just a lack of proper enforcement there. The rules are somewhat there, but we're just lacking enforcement.
So it's still in its toddler phase, but we'll see when it starts running. I see James. I think you have a question. So if you want to unmute yourself, since you've got your video. Let's see.
So I had a question about whether anyone foresees the definition of likeness rights being expanded as we move forward to include metadata, perhaps, or a online, like full search and HIPAA and genomic, even personality or characteristics to include likeness rights, and if there's been any motion or movement on with the O'Bannon and NCAA to that.
So I don't know if I'm quite familiar with the issue you're raising. Are you, when you say likeness rights, are you talking about kind of inferences and, you know, in the case of, you mentioned genetic data, the fact that as an individual, when you make it, you know, an individual choice to share your genetic data, you're also kind of bringing in relatives and other people related to you. Is that what you mean?
Or no, more on the side that likeness rights is right now a visual kind of likeness. I believe the courts have defined in this, especially when it was in terms of how we're selling or marketing an individual's likeness online or in advertising. But
Okay.
Is there any way that will, if you have not given consent for your personality as a whole through and all the things that are being collected in this way to be sold on to a third party, if that would be expanded into a violation of any kind of likeness rights?
Yeah, I'm not sure. I feel like your question is edging into intellectual property questions, and which I have to say is just not my field. So I'm not entirely sure. Jana, do you have any thoughts?
Also not sure if I'd be answering a question there, but if we're talking about inferred data, that would be covered under GDPR, for example. But I'm not sure how the discussion's revolving around a federal privacy law in the US when it comes to these kinds of questions.
Yeah, I apologize.
All right, well, sounds good. James, any additional rejoinder that you would like to ask or anything like that on the topic real quick?
Yeah, I mean, as an employer, we're seeing a lot of questions on collecting of data of our employees and passing it on, especially in this time. And it's coming on fast and almost with a mandatory kind of vibe. They're presenting it to us, be it I'm seeing this from landlords or shared workspaces or just from the states in general. But, and under the guise of there's been relaxations on ADA and HIPAA and EEO, but what happens when that stops being relaxed and how does it get audited later and what happens to all that information and is that a slippery slope? And it,
So yeah, so it sounds like Jen and Jana, the question about, you know, how do employers make sure they are responsive to possibly requests from local or federal government amid the COVID-19 crisis now, recognizing that the COVID-19 crisis will hopefully end at some point in time too. So, and caveating that none of us, I think, are lawyers on this, and so none of this is meant to be legal advice. But Jen, maybe Jana, do you want to, what would you recommend in the COVID-19 era? And then we'll go to Dan, and then we have some additional questions after that too.
I feel like that's really a question that a US lawyer specialized on US privacy law should answer, not in a webinar maybe. I don't know. I mean, I literally can't give legal advice on this. Like, I can tell you how I would deal with it in Europe under GDPR, and you're always on the safe side with consent, with proper consent. But other than that, you're really getting into the details then of under which conditions and with HIPAA and everything. I mean, I think I can help you.
I mean, we can't build an AI that can answer this. What, you know?
Yeah,
Stephen, looks like
if I may, you know, yes. I think this question is really good and has been at the heart of a lot of really kind of interesting conversations the last couple months. And I think that, you know, one of the really good things to come out of this pandemic and kind of the data response is a heightened awareness of privacy. You know, as these safeguards are being eroded away and, you know, as we start seeing, and this has been a trend that we've seen for the last few years where, you know, there's startups that want to harvest employee data for a whole range of things. And some of them are, you know, more above board than other things. And I think that this is the question that's at the heart of notice and consent, right? And how do we actually understand what is being extracted from us is one way to look at it. Yeah. And, you know, how do we have some agency in agreeing to that? And you know, what is that slippery downside slope if we don't agree to it, right? Are we going to be removed from functioning of civil society by not being part of that? Does our employment change You know, I'm penning an article right now about, you know, mandatory contact tracing, and we can put mandatory in quotes, but you know, what does that look like? And I think that employers will be, you know, exercising contact tracing as we go forward. It's definitely a different concern, but if you look at it from kind of this balanced perspective of their objective is to keep people healthy, right? And like, how do we do that? And in the absence of, you know, maybe a government authority that's doing it in some parts of the world, then, you know, then the more close that gets to your community, and the more that you have kind of that customs as a source of law kind of thing, you know, I think that's where we're going to end up. And it's going to be a set of interesting questions, and employers are very much at the center of it right now.
Thank you, Stephen. All right, now we're going to go to Dan. You've been very patient. Dan, it looks like you have a question. If you could unmute yourself.
Hi, thank you so much so far for this fantastic conversation. Really love the overview of topics. My question is really about one of the themes that you had mentioned, which is thinking about alternative business or revenue models that you think better align ethics and privacy as part of the organization's strategy. You pointed to something really interesting, which is that ultimately, if companies are doing this out of fear of a penalization from law, ultimately, if their business models benefit from a lack of notice of consent or the mass harnessing of data or the secondary use of that data potentially harmful ways, that's ultimately more, you know, punitive and down the line versus how do we make that as part of the design of the business itself, which is really interesting. It's trying to take this idea of data privacy by design to not just the technical infrastructure, but also the business strategy. How do we make it a core ethic? You mentioned the fiduciary concept, which I think is really interesting. And I see that some of the data trusts and data cooperatives are starting to have fiduciary responsibility as part of that design. But obviously that's more of a alternative sort of business model that's more democratic and bottoms up. I'd love to hear if you think that there are any other interesting business models on the horizon that can kind of make data ethics as a strategy as core to the business revenue design.
So a couple things. I think one of the big tensions here are solutions that focus on the individual and solutions that focus on more of a collective kind of approach to privacy. And it may be that context is part of what drives that. And it really will depend on the context of the data that you're collecting and kind of the use of it. You know, and I think genetic data is a good example of that, because you have a business like 23andMe that, you know, kind of suits both needs in a way. Like, I mean, I think in some ways it's a brilliant business model because you get what I think of as the individual narcissism. You know, I find out all about me, but then I'm also contributing to a greater good. So it kind of hits both spots. And so I think some of what I've seen has been business models that are focusing on the individual data management question. And so, you know, whether that's the data agents that I talked about in some form, or, you know, different approaches that try to make that individual data management piece more reasonable and accomplishable. But I think that can't just be the end of the story. And so there needs to be thought around more the kind of collective side of it as well. And I think that's where the data trust piece potentially comes in. And the fiduciary model, I think, is potentially the kind of way of explicitly trying to bring ethics into this whole situation. But, you know, I don't know if a single approach works for kind of every business out there. And again, I think context is really going to matter. And so, you know, if you're collecting data broadly, you know, from, let's say, a smart city, for example, then it might be that, and it's interesting to have this discussion in the fact that Sidewalk Labs just, you know, folded that project in Toronto. But, you know, to the point that we kind of are instrumenting, you know, public spaces and collecting data about us all on a more general scale, that might be more of an appropriate way to think about data trusts, you know, and these more collective ways of managing data, rather, you know, as opposed to, you know, the kind of touch points where it's all about me and my data and my individual relationship with a company. I know that's not a very clear way of answering your question, but I just think that context is really going to matter. In terms of, you know, privacy by design, it's kind of an interesting I think we're at an interesting stage with privacy by design, because to the extent that I've been following, and again, from an academic point of view, so, those of you in the industry will have potentially very different perspective. It's kind of a way of trying to force these issues. And my critique of it is that so far it's become more of a compliance maybe approach rather than a kind of more context respective approach that really brings in the individual users into the question. At least that's been my kind of external critique of it. That said, I've had some discussions with a company that has had some privacy by design orders enforced against them, and I did see some interesting kind of approaches to the way they were kind of dealing with product development and questions now that I hadn't seen before. And so I do think those kind of sticks tend to drive improvements, but whether, I feel like privacy by design is still very unspecified in terms of really being able to provide a company with good guidance on exactly how to incorporate that into the design process, other than, make sure you have somebody around who understands privacy on some level. Do you have any, I don't know if that helped. I don't know if you have a follow-up or to Dan.
Dan, any additional follow-up you have real quick on that? Or are you good? You're still muted. You good?
Oh yeah, no, that's great. I think that touches on a lot of the same themes that I was hoping for, which is that ultimately, like to your point about privacy by design, ultimately, if it's simply going to be a compliance and technical approach, it may be limited if the larger goal of the organization might be somewhat antithetical to better uses of data. You're talking about use context, and I think of like purpose limitation when I think of that, and thinking about like what was the purpose that the data was used for. How do we make sure that additional secondary or tertiary uses are used rationally related? And so I 100% agree with that. I kind of like this, renewed interest in things like public benefit corporations and cooperatives and B Corps. World Economic Forum is now talking about stakeholder capitalism. How much of that is simply, ethics washing or whatnot? But I think that there is something interesting there around how do we create the governance around those organizations and those shareholders and those stakeholders that are using this data so that they're more aligned with societal and collective benefit. Pushing that discussion, I think, is super interesting to me. So I appreciate your comments, and that's kind of where I was coming from as well, is that I want to push it simply from a technical approach to how can this be part of the strategy of a business of the future.
I think fundamental to all that is trust. And so, we're at a point right now where trust in tech is at an extreme low, at least in terms, I think, of consumers. And so, I think if we're really interested in building, systems that kind of, increase trust, increase customer trust on some level, then you need to think about how to be transparent and to kind of give individuals, some amount of power. I just don't think that, I think that we have to look at kind of both pieces as we described, that if it's just a focus on kind of giving individuals power, it doesn't really deal with, kind of the privacy issues that to me are more collective in nature and more societal, inferential, things that are much more less about whether what I shopped for versus, whether you understand where we all go, every day, which, of course, contact tracing, I think, is a really good example of that.
So we have 3 lineups. We're going to go, just to give the lineup so folks know, we'll go to Andra, and then we'll go to Karen, and then we have someone at area code, or the phone number at area code 6206, which I believe is, I've been told, is Scott David. But first, Andra, if we could go to you and your question, that would be great.
Yes, I couldn't unmute for a second. I want to complicate things slightly, because so often the debates around privacy do fall back into the kind of trenches of the individual or the borders of what we see the internet as being, which is, browser-based, laptop-based, phone-based, and so forth. Representing robotics, I see this is becoming mobile. I believe every robotic device is effectively a form of communications technology. These days, they are all almost certainly internet enabled and are engaged in real-time communication of that data. And so I was first wondering what advances were being made in the data trust or extraus of data around perhaps some of the most further forward areas of self-driving vehicles, and not just cars, but delivery robots. But as you mentioned, Sidewalk Labs recently collapsing, what I see is that all of these areas are crossing multiple boundaries in a way that complicates this discussion tremendously. Whether it's, you know, in the case of a self-driving car, being first on the roads and second in local areas, thirdly in states and fourthly in national areas, plus the battling between car companies, which has, if we were hoping for the industry to self-regulate and create forms of data escrow, then what we're seeing is that that's not necessarily being driven by the industry. We're starting to see the same thing happen inside malls and supermarkets, in the sense that we now have multiple companies developing robotic solutions for these spaces. And if anything, there's more power to force compliance from your Walmarts and your Targets than from anything else. And they're looking at flexing their muscles in terms of forcing compliance to, say, share maps, which is a really big IP thing. But given that they will be effectively responsible for the umbrella of privacy for everybody who's being monitored by devices within their umbrella, are we seeing anything from that side of the fence in terms of data trusts or data escrows?
I haven't yet. I will say I am not the world's expert on data trusts. Luckily, I'm friends with some of the world's experts on data trusts, so I know the people to talk to. My sense is that it's mostly been looked at in the health context so far. And certainly with the current pandemic, there are some questions being raised around whether data trusts are an appropriate response to dealing with pandemic-related data. Because I think health seems like one of the more obvious ways in which collective level data would make sense, because you see most of the benefit of data sharing and kind of data analysis, and that's obviously a very large group rather than kind of individual one-offs. So I don't have a kind of clear answer to your question, but I think it's an excellent one, and it raises, I think it raises some really interesting kind of questions around, my sense right now is that the current, at least in the US, the current regulatory environment around privacy and data really creates a race to the bottom, in the sense of, there really are no incentives for companies to not collect as much data as they possibly can. There's no incentives to not collect, and sell as much data as you can. The CCPA is maybe one of the first kind of ways in which companies at least have to now be more explicit and transparent about what they're doing, but it doesn't necessarily restrict those uses per se. And so the way I'm thinking about what you raised is to wonder if, it seems like what would be more useful is to think about the ways in which we could collectively create something like a data trust for data that companies can all potentially, use in common, rather than everybody's kind of stockpiling their own silo. At least that's how I'm interpreting how how you presented that. And it seems like in certain contexts there might be more of a middle ground for different players to meet and try to argue for a kind of collective. I don't mean collective in the kind of communist sense, but just the word I'm using. But more of a kind of commons-based approach to using data, that has some safeguards around it, rather than this kind of current siloed, everybody's grabbing what they can, and it's a very much a competitive issue. And I'm curious to hear the reaction to that, because I don't know how naive that is from an academic point of view, to assume that we can find a way to kind of meet in the middle and explore ways in which it just makes more sense for the different actors to try to kind of work from a same set of data rather than kind of individually monopolize it. We certainly have seen the success of, well, I don't want to throw around the monopolization word casually, but certainly there are real big concerns right now with the major platforms and their access to kind of data on a broad scale. Clearly it's a source of power, but there's obviously a lot of concern about that concentration of power, not just by policymakers, but across a lot of sectors. And so, I guess I could see the possibility of whether it's a city level collection of, kind of trust of data across all the ways in which one might instrument a smart city. You talked about shopping malls. I mean, I don't know if that's something, kind of an open API or just kind of open data for consumer use of, products in that, that particular context. I mean, I can see the possibilities. I just don't know how, from an industry point of view, how realistic you all think that would be.
If I may add to that, I'd love to see more data trust and escrows in these areas as well. We just have a huge incentive problem there, because we're thinking about data trust because we want to avoid having to say, I consent a million times over each day, like we have to do online when we're browsing websites right now, at least in Europe, because we have to click the I consent to these cookies button all the time.
Literally.
But I don't have that legal obligation in at least most of the fields that you mentioned yet. I don't have to, for example, if someone else is using a self-driving car, I, as someone who's just walking on the road, I don't have to consent to the car filming me while passing by and then erasing that data right away, not even in Europe. So there's no legal need to have these data trusts there right now. So I think we're having an incentive issues, but it would obviously be great to see more efforts.
Any real quick rejoinder that you have before we go to 2 other questions, or did that help answer what you needed?
That was a great answer. I cede my time to more questions. You've got me thinking.
All right, thank you.
That was a great question.
Just so folks know, well, technically we have only about 4 minutes left. We're probably going to go another 5 or 10 minutes if people allow, because we have 2 additional questions and then we'll wrap. Karen, if you could unmute yourself, it looks like you have a question if you would like to ask one. Oh, you're muted again. Sorry.
I'm good. Thank you. And I'm sorry to have joined late, so I don't want to retread ground. I will confess that I'm an antitrust lawyer, not a privacy lawyer. So I'm enjoying the conversation around monopolization versus collaboration and cartels, because we worry about it in both directions. And I think that's going to be one of the thornier issues, is sort of what level of collaboration are we going to tolerate or even encourage to sort this problem. I guess what I'm separately interested in is not even so much what I think is traditionally considered a privacy concern or consideration, but really a use concern or consideration. And I say that because in talking to some of my friends on the technical side, that they're also anticipating a time where data is not, vast quantities of data aren't going to be the issue. It's going to be instances of data that then get compared to sort of historical learning, right? That we're going to sort of outgrow, and for some uses, we're going to outgrow our need for data at a mass scale. And that becomes then a more poignant questions around, so how are we combining data, to what uses are we putting the data, and how are we consenting or regulating that, as opposed to the collection and storage and security kinds of concerns. And so I guess my question, I'm thoroughly unsatisfied by any of the sort of regulations and constructs that I've seen out there in terms of dealing with that future state, which is what I really think is where we're headed. And maybe I could be completely wrong from a technical perspective, but I feel like there's a huge divide or chasm between sort of how we're talking about data and trying to regulate it. And I'm thinking about Washington State's new law, or almost new law around, and how it tries to tackle facial recognition technology, and it just kind of doesn't. So it's not a very well-formed question, but are people thinking about data trusts or these other constructs in the context of a world in which it's really about combining and usage more than it is about quantity and security? That is a really interesting question. You guys don't hold your punches in the forum, but it's a great question. So in part, I don't know, honestly, in terms of kind of the larger questions around, or debates around data trust, if that perspective has been brought to bear. I'm certainly sure in terms of regulations, it's not being brought to bear, because I feel like so much of the discussions around data specification in particular is very much you collected it for X, you can only use it for X, and maybe some other
uses, related to X, but, it was for X and that's what you have to stick to. And so I could see vehicles like data trusts, again, I guess with some amount of oversight, and that maybe is inherent to the fiduciary kind of nature of a data trust, or a vehicle similar to that, being a way to try to work through those issues you raise, and not from a perspective of just trying to get away from consent, which, in some ways, at least with that situation, you do, ideally kind of bypass the need to kind of individually kind of ask and re-ask and re-ask and re-ask. But yeah, to take that kind of longer term view around the use of data, I could imagine it being used in that way. And I'm sorry, I was thinking so hard about my response, I'm starting to lose track of where I was going with it. I think it's a really complex future situation, and it's certainly not something I've heard discussed at all in the regulatory context. But it's fascinating, and I'm going to pause and kind of recollect my thoughts in case Jana has anything she wants to add, because I want to dwell on that one for just another second.
Actually, I'm an advisor for one of the members of the European Parliament right now, and the word data trusts falls in every lobby meeting that we have. All the companies, they're super excited about data trusts, and the issue that we're facing in Europe, at least, is that under GDPR, the concept is just more or less unthinkable right now, because we have this concept of purpose limitation when I collect data, and not necessarily based on consent. There are other legal grounds in which I can collect data, so I don't even need consent sometimes, or actually most of the times. But I always have purpose limitation. I always have to be able to pinpoint to the exact purpose that I once collected the data for, and that's the only purpose I can ever use it for. So that totally contradicts the concept of data trust. And I guess we all agree that it's a concept at least worth exploring, and which can offer tremendous benefits. And companies right now are super concerned about how we can create a legal framework for it to provide for these kinds of concepts. And what I'm noticing in the US right now is that at least under CCPA and also the privacy law that Washington State proposed, or I think they already implemented it, is that they are at least partly modeled after GDPR. So they're kind of taking on board some of the same concepts or key aspects, or how you can structure notice and consent. And I'm not sure that the concept of data trust can function under these legal frameworks. So we definitely have to rethink them. But I haven't heard from anyone any concrete ideas on how to do that without opening Pandora's box. So this is something that's still being worked on.
Oh, sorry, Anna, I was going to say maybe to possibly give you a concrete suggestion to think about, and then we've got one more question. But this sort of ties to what James had asked earlier, which is you may give consent for data to be collected about you, but are you also needing to give consent that says, can you generalize that people of my demographic, of my age, of my zip code, in general have this credit worthiness? And so the question is, when you give permission to have data collected, do you also need to ask the person and say, I may have given permission to collect my data, but I didn't give you permission to generalize and compare me to others? That may not be very true. I mean, I may have perfect credit, but maybe I'm in a up and coming zip code. And so in my zip code, not everyone has perfect credit. And so you're concluding with no data that I have bad credit based on my zip code, even though you never actually collected it about me. And so I think that's getting to what I think Karen was saying and what James was talking about with likeness is, do we need to give consent to be compared to?
Yeah, just to add one really quick closing thought on that. I think so much of what we're seeing around purpose specification is a reaction to concerning behavior that we've seen by companies, just this sense of like, it's a limitless fishing expedition. Once I get your data, I'm going to do anything I want with it. And so I think that maybe a way to rethink this is trying to create context in which we create data where we acknowledge that there'll be kind of speculative uses, and that we potentially maybe limit the types of data that we use for those speculative uses, but I guess creating a structure that's more honest about that and is more specific to that purpose, with the acknowledgement that there are probably types of data that would be off limits for that. I think I kind of see maybe thinking about it in those terms as a way to try to resolve this, because I think, again, so much of the reaction on purpose specification is just like, company X did something that we don't like, we want to kind of punish company X and try to keep that from happening in the future. And so it'd just be a more thoughtful way of kind of rethinking how to put value on the use of data in these ways with some guardrails around it.
Excellent. All right, and we have one more question. I'm going to unmute the individual at area code 206. You are now unmuted. Oh, now you're able to ask your question now.
Hello, can you hear me?
Yes, we can.
Excellent. This is Scott David. And so people who know me will be sorry that you unmuted me because I'm a wordy guy. I'll be really as quick as I can. Great conversation. Wonderful. Couple of suggestions. A, I'd love to continue this conversation by email with exchange of materials and stuff like that. We can do this among the people on the call. A lot of what we've been talking about is hand-wringing about the state of affairs out there. But most of what's going to be solutions here is probably first not going to be regulatory or public laws, but rather contracts and policies and language. And that language is something that we people on this phone and the people on our networks could put together as frameworks. So that's just observation A in terms of our efficacy. That last point that was made in terms of what these are going to look like, I think the data trusts, a lot of what we talk about as data trusts are really data pools. And one of the things that we're moving towards, and I think will ultimately end up there, is looking at data as a co-managed resource. And I'm not using the word commons, but that's essentially the idea. And so part of the problem we have, and there is a question at the end of this, part of the problem we have is that data is a dual-use technology. It's like saying we outlaw hammers because they can be used to hit people in the head, but we don't do that. We make hammers hard, and then we say don't use hammers for hitting people in the head. So we do address the harm, and data, to me, feels like the same kind of thing. Those fair information practice principles, anybody who hasn't had an opportunity to do so, find an article by Bob Gellman, G-E-L-L-M-A-N. Everyone got that article? And read it about FIPS. And so the question is, and I'm going to circulate, so I can circulate something around about this. And this is, so trying to address that next thing to try to dissipate some of these problems. What if data is not the problem? What if information is not the problem? What if liability is not the problem? What if privacy is not the problem? What if the problem is Moore's law? And the fifth order effect of Moore's law, basically that Moore's law that transistor densities went up on chips exponentially, right, doubled every 18 months. The fifth order effect of that, I won't go through the 5 orders here on the question, but the fifth order effect of that is that interaction volumes have gone up exponentially globally. The ability to collect, process, and transfer data has gone up exponentially. And none of our institutional constructions are fit for function. And that's part of the Gellman problem, is the FIPS, fair information practice principles, were made to constrain data flows. Well, that genie's out of the bottle with an interaction density increasing. So what I'm wondering is, what if we took an approach that's like what banks took early on? If you look at data as adding leverage and limiting risk potentially when context is added to it, there are theories of money that look at money as a risk consolidation tool. If you get money, you can take care of other risks you have. And so after 2008, after the financial collapse, all those excesses, there were people in the UK talking about narrow banking. And in narrow banking, what you did is you offered security and some leverage services, basically checking accounts and safe deposit boxes, or savings accounts, check deposit boxes. And so instead of people keeping the data or the money under their mattress locally, they kept it in these entities, and they had both fiduciary and non-fiduciary obligations. If I take $10,000 into the bank and I put it in a safe deposit box, that's a fiduciary relationship with the bank. They can't use that money. If I take the same money and put it in a checking account, that's not a fiduciary obligation. They have a contractual depository agreement obligation to return a similar amount of money, but they do put that money to work. So that last comment that was made about, hey, what if there was a class of data that the user, the person, the data subject, us, could specify, hey, I want this one, go put this one to work. This is good. Or go put this to work in a pandemic, or go put this to work for money and pay me interest, or pay me a royalty on it, or pay me liquidated damages if you misplace it. So anyway, the question is, might there be a pathway that we could start to construct among these people in this group to start to look at the de-risking and leverage that money does, and then construct business, organizational, legal, technical, and social interactive, interrelated structures, bolts is what I start calling it, to address those many variables that go in there that we've been talking about on the phone today. It's been a great conversation, but we haven't disambiguated the idea of privacy. And if we want to create rights that are defensible, individual rights that are defensible, we have to start talking about specific rights and then those specific duties that will use the bolts elements to normalize and make them reliable so that reliability can lead to trust. And so that's the question is, can we take those money systems without losing our souls and redeploy them to the service of individual empowerment? So sorry for the long question, but a great conversation today, and that led me to that conversation, that question. Thanks.
That's a great comment, and thanks for highlighting Bob Gelman's work. Yes, if you want any history on the FIPS, he's the person to read, absolutely. And just, I'll keep it short because I know we're at time. I mean, I generally agree with what you said. I think one of the pieces that you mentioned is the disambiguating privacy piece. I mean, one of the most complicated things about privacy is that it's not a kind of binary yes/no issue. You know, it implicates a lot of other values in it. And so while I look at my work through the framework of privacy, I mean, there's so many other things kind of tied into it: trust, power, you know, just ethics in general. And so privacy is one way of framing it, but absolutely it's not kind of the only value at play. So I think that's a good point to make. And I find what you said extremely interesting, but I want to pause. Jana, do you have any last thoughts that you want to add?
No, just agreeing with you. This is an extremely interesting concept, and please do some lobbying on the federal level in the US for this, because in Europe I don't see any reopening of the GDPR anytime soon. So you have the chance to get this right now.
Now's the time for US to finally step up to the plate, given we've seen what Europe's done, we've seen what China has done or has not done, and so maybe the US can chart a third path. Do you have a real quick comment, Scott? Before
I was just going to say, draw a chart with an interaction curve of exponential increase, and you'll see even under GDPR, I think there's a lot of interaction space that's being opened up that isn't yet anticipated by GDPR. It may be hard to be consistent with it as we identified in the purpose limitation, but with contracts, at least we can start to bound GDPR appropriately with duties that'll be consistent with it when appropriate, but not have GDPR being bleeding out into all sorts of other stuff, because really, quite frankly, it's not fit for function in the future. So anyway, we'll have a chance to talk more.
I think we've teed it up for a future Data Salon series. Real quick before I wrap up, I want to first thank both Jen and Jana for your wonderful remarks. Clearly, it's a testimony that we went into over and people stayed. I would ask real quick before we wrap up, if you could give 2 to 3 tweet-linked answers, and so we have to keep this short, to recommend what people could do, whether they're in a organization or they're in a different capacity. What can we do as steps going forward? And maybe Jen, I'll go first to you, and then Jana for 2 to 3 tweet-linked answers before we wrap up.
Oof, what can we do? So I think I find talking to private actors in the US often to be frustrating, because there's just this assumption of no regulation, no regulation, no regulation. And so I would first encourage you to not take the completely anti-regulation approach. That's not really tweet length, I'm sorry.
That's okay.
I think in the short term, yeah, I don't know if I can give it a tweet length. I mean, really one of the things I'm looking to do is try to build a kind of a coalition to deal with these issues, because I think in general, we can't do it without industry coming along for the ride, and especially kind of dealing with the incentive issues. So to me, as I kind of, look forward on my work, I feel like, partnerships across academia, the social justice groups, but also industry are really important. And so I guess that would be my appeal, is that you, look to engage with not just me, but, other people in the space who are, trying to solve these problems, and definitely not just keep it to industry.
Excellent. Thank you, Jen. Jana, closing tweet thoughts?
I don't know, maybe also not tweet worthy, but one of the thoughts that popped in my head over and over during this conversation was that I think consumer trust is key in this area, and we don't need to see regulation as our enemy or privacy rights as our enemy to our business model. We can take them on board and integrate them in order to build consumer trust, and I think that's the way forward.
Excellent. Well, I want to thank you both. This was a tremendous conversation. For all the people that were on here today, if anything that you wanted me made non-attribution, please let us know. We can do it. Otherwise, we will share a recap of this event with people afterwards. I want to also thank our partners at Accenture and Stephen in particular. Please save June the 17th, same time, same place. We'll be gathering again for the next Data Salon discussion with Davi Oppenheimer from Interrupt. And we'll be doing additional conversations that'll dive deeper onto data trust in historical context for everything we discussed. So everything that's been raised here about let's build a coalition, let's see what we can do forward together across sectors and industry, we will move forward and address. And thank you all for being positive change agents.